Good morning, dear colleagues, candidates and society. Today, 18th May 2025, the advisory group of experts is gathered in full composition to interview the candidate for the position of judge of the Constitutional Court of Ukraine, Smokovych Mykhailo Ivanovich. In particular, all 6 members of the AG are present. AG Secretary Ms. Marine O'Connor, AG Member Ms. Hanna Sukhotska, AG Member Yaroslav Romaniuk, Vasil Shakun, Mr. Alesh Zanar, as well as myself, AJ Chair Oksana Vasilchenko. Also present during the interview are deputy members of AG, Mr. Vitaly Mahichuk, Mr. Thomas Griffith, Mr. Richard Bart, Mr. Richard Zubik. I would like to note that we are working in a shelter, so in the event of an air raid alarm, the interview will continue without interruption. I would also like to remind you that the interview is being recorded and broadcasted live on the AG and CCU websites. I would therefore like to draw the attention of AG members and the candidate to the restrictions on the use of sensitive data and restricted access information during the live broadcast. If necessary, the AGE will restrict the broadcast for the duration of discussions. We are ready to begin, so I give the floor to AG Secretary Ms. Marine O'Connor for a brief introduction of the candidate and a reminder of the interview rules. Please, Marine, the floor is yours.
Thank you. Good morning. Greeting colleagues and everyone who is watching us this morning. As our chair has already said, the advisory group of experts will now interview candidate Smokovych. I would like to remind you that the interview is part of the candidate's assessment process to determine their compliance with the criterion of high moral quality. As before, each interview will last approximately 1 hour, and the time limit for answering questions is 3 minutes. As usual, we ask all candidates to be concise and to answer the questions clearly, unambiguously, and to the point. At the end of the interview, the candidate may make a brief closing statement of up to 5 minutes. I would also like to note that while reviewing the materials on candidate Smokovych, the advisory group sent him questions for written clarification, so the candidate has had the opportunity to prepare and to provide answers. I will now briefly introduce our candidate. Mr. Smokovych has been the Chief Justice of the Cassation Administrative Court within the Supreme Court since the 6th of December 2017. He has nearly 30 years of judicial service, having served as a judge of first and appellate instances, as well as judge of the High Administrative Court of Ukraine, where he was secretary of the plenum of that court for more than 11 years, and also held the positions of Secretary of the Judicial Chamber and Deputy Chief Justice of the High Administrative Court of Ukraine. Mr. Smokovych is engaged in scientific and teaching activities. In 2010, he defended his candidate of legal sciences degree on the topic Problems of Delimitation of Judicial Jurisdiction and Determination of the Competence of Administrative Courts. And in 2015, he defended his Doctor of Legal Science degree with the thesis topic of theoretical foundations of legal regulation of the consideration of electoral disputes by administrative courts. He currently teaches at the National University of Ostra Academy. He holds an honorary title of Honored Lawyer of Ukraine. He has already taken part in last year's competition and had an interview with the advisory group. Mr. Smokovych, if you'd like to add anything to your introduction, you can do so now, taking up to 3 minutes.
Thank you so much. The introduction was full and comprehensive. Nothing to add. Thanks.
Thank you. Thank you. Colleagues, you may begin the questioning.
I will start. Good morning, everybody. Good morning, Mr. Smokovych.
Good morning. I would like to file a motion. If you don't mind, Can I just start with challenging the conclusions you made last year? Is it possible?
You will have a possibility to explain your views through the answering the questions, because the questions I intend to pose are directly related to the previous opinion and decision of the AGE. So I will start with the first question. You actually was participating in the competitive selection, as you know, and you received the decision of the AGE, in which AGE expressed a number of reasonable doubts. And in the course of the current competition, you have repeatedly provided written explanations and documents to refute these doubts. So taking into account these written explanations and documents, advisory group still have some questions to clarify the open issues. And the first open issue relates to the apartment in Kiev you obtained. And it relates to the number of family members, including your mother, who was registered to live in a 4-room apartment in Kiev from May 2007 until August 2010, when she changed her place of registration to the village of Veliki Kurin, and this is the Volyn region. Now the question is that what period did your mother actually live in this apartment with you in Kiev? This is still not completely clear, because it seems that she was actually living in another place mentioned before.
So let me provide explanations regarding the period of her residence. She resided there since 2009, approximately January 5. She moved in before Christmas, and she was in Lutsk on Easter. So it's approximately third decade of April. So I now provide you exact time frames.
So you claim that she was living with you in Kiev?
Yes, I do.
Now, in your written explanation, you stated that your family at that time needed a 4-room apartment, correct?
Yes.
Yes. And one room would be needed for the spouses, a second room as an additional space for you as a judge, and then 2 rooms for children, as they are of different sexes. And then the Housing Commission decided that your mother could live with her granddaughter in 1 room. That was your explanation. However, you did not provide any written confirmation of this latter circumstance. So that's an open issue. And furthermore, the apartment was allocated to you and your family on 19th of March 2007, in accordance with the order of the head of the local administration in the city of Kiev. And at that time, your daughter and son were 3 and 8 years old, respectively. Therefore, they were not subject to the legal prohibition on sharing a room. How can you explain these circumstances?
I can explain the circumstances in the following way. So, in reality, and it's proven, the mother was my family member, and the apartment was allocated for 5 people. But since I have children of different sexes, when the order was issued, my son was 8.5 years, his daughter was 3.5 years, but according to the law, upon moving into apartment, there is a concept of moving in. So when we moved in, the son was 10 and the daughter was above 5. So it was a requirement of the law. And I think it was a reason behind decision of the Commission. They saw the condition of the house and apartments allocated for judges. So the issue of order and actual moving in are 2 different things as per our housing legislation.
Well, according to the Article 50 of the Housing Code of Ukraine, when providing residential premises, it's not allowed to occupy one room by persons of different sexes older than 9 years, except, of course, for spouses. So this is at the time when actually you are provided with such an apartment. But thank you for sharing with us your opinion. How did the registration of your mother's residence in Kiev and her inclusion in the family affect, if at all, the total area and number of rooms your family received?
As for total area of allocated apartment, the apartment was provided for 5 family members, including my mother.
So actually, the fact that your mother was considered as a family member contributed to the final decision on the size of the apartment, correct?
Так.
Yes.
I have another question which also relates to the previous decision of the AGE. In 2019, your wife ended her 25-year career in the prosecution service. Has she been practicing law since then?
No, she doesn't. No, she doesn't. No legal practice. The only thing, she was once invited as a training to train young prosecutors at the prosecution academy. It happened several times, so she was a training facilitator. But it's not a legal practice. It's...
I understand. As your written explanation show, the situation of your wife's dismissal in 2019 is somehow complicated or not very simple. She initially agreed to undergo a performance appraisal, then sent in a statement of refusal to undergo the appraisal, but the personnel committee interpreted this statement as unsuccessful completion of the appraisal. Indeed, your wife did not challenge the procedure, and as you state in your written explanations, your wife's unwillingness to undergo the appraisal procedure was dictated by personal motives. However, in fact, this procedure ended her long career. Don't you think that an objective observer might consider that you have developed a personal negative attitude to the procedure of the attestation of prosecutors in view of the above circumstance?
Thank you for your question. My spouse was dismissed in line with the law effective back then. According to the law, those unwilling to undergo performance assessment had were dismissed due to failure to complete performance assessment. It was official wording. So the prosecution bodies fully complied with their obligations. And as for unwillingness to undergo performance assessment, it was her personal considerations. She didn't want to participate. But, I'm sorry, excuse me. But,
Go ahead.
so, you asked me about reasonable observer. Well, my spouse did not want to do it. It's her constitutional right. It was voluntarily. She was dismissed, and the order uses the same wording as in the law. The law was fully complied with. She did not challenge her dismissal. She did not file a lawsuit. So I don't see any reasonable grounds to believe that observers may have any doubts. So when regarding the situation when I, as a judge, hear cases involving prosecution bodies.
This is actually one of the worries of the AGE, which, of course, was the ground for previous decision, the issue of potential conflict of interest or non-recusal in situations where, in the eyes of an outside reasonable observer, it could be considered as a violation of the due principle of respecting the impartiality. And the same issue relates to the situation with Madam Alla Basalayeva. When exactly and under what circumstances did you meet Madam Basalayeva?
Madam Basalayeva, well, I met her in fall 2005. When on September 1st, 2005, the administrative procedure was launched in Ukraine and the election of members of parliament 2006 started, the electoral process started. Back then she worked as a Central Election Commission. The electoral process started in November 2006 and there was intense flow of electoral cases, and the Supreme Higher Administrative Court acted as a court of appeal in cases involving complaints against Central Electoral Commission, and Ms. Basalayeva was a lawyer at the Central Electoral Commission. She represented Central Electoral Commission. That's how we met. No one introduced us to each other. We met during the court hearing. During the court hearing, I learned about the existence of Alla Basalayeva as representative of Central Election Commission.
Explanation. And during your interview with the advisory group of experts on 22nd October 2024, you stated that it was Alla Basalayeva who, and now I quote, asked me to become her scientific supervisor. When exactly did this request take place? And why did you accept it?
She made this request when she was passing her postgraduate exam at Shevchenko Kiev National University, and I did not refuse. I accepted this request. Back then, she was already a judge. She reasonably explained her motivation, She wanted me to become her scientific advisor because her topic involved the protection of electoral rights in Ukraine. Back then I was a doctor of legal science, and it was my main topic of scientific interest. Therefore, I accepted.
Do you remember the date, at least a month in a year, when she asked you to become her scientific supervisor?
Well, I guess it was 2016. This is the only thing I remember.
In your written explanation, you state, and I quote, course in a situation where Madam Tsalaeva would be personally interested in the dispute being resolved in court with my participation, this would require me to take measures to eliminate doubts about impartiality of the court. So, should we understand that as a result of long-term cooperation, you and Madam Tsalaeva have developed certain personal relations that would compel you to recuse yourself?
Thank you so much. I have never had any private or personal relations with Madam Basalaeva. I had only professional relations with her.
And how intense were these professional relations with her?
Our professional relations, when she worked at Central Electoral Commission, she quite often represented Central Election Commission. She was very professional, very competent, and when representatives of governmental agencies are competent, it makes life easier for a judge. When she became a judge herself, when she resigned from Central Electoral Commission, I actually didn't even know it. I learned that she resigned after many years, resigned as a judge after many years. I didn't have much communication with her.
I have another question. On 13th March 2025, the advisory group received from the Cassation Administrative Court within the Supreme Court minutes number 1 of the meeting of judges of the Judicial Chamber for consideration of cases on taxes, fees, and other mandatory payments, dated 11th March 2025. According to these minutes, on 11th March, you submitted the secretaries of the judicial chambers of the Cassation Administrative Court within the Supreme Court the decision of the advisory group on your non-compliance with the criterion high moral qualities for the judges of the judicial chambers to review it. And at this meeting, paragraph 6 of this decision on possible favoritism in the election of judges to the Grand Chamber of the Supreme Court was discussed and judges' position on it was expressed. Since this meeting was initiated by you and concerned only an individual decision regarding you, don't you think that an objective observer might have a reasonable doubt as to whether you are using your position as the Chief Justice of the Court in good faith for your personal purposes only?
Thank you. As a chair of the court, every Tuesday at 8:30 a.m., 30 minutes before the working day starts, I have a working meeting with secretaries and employees. every Tuesday. As for this particular situation, after I received opinion of the advisory group of experts, I had a dilemma. What were I supposed to do? Should I move to a different chamber to other body which do not require such authorities, such as state audit service or prosecution body? Should I change my career? Are there any reasons for me to recuse myself as a judge? Or maybe I should delve deeper into each case, looking for reasons to recuse. Therefore, I asked the Council of Judges, which, in line with the law, is a body responsible for provision of such clarifications to judges. I was invited.
Yes, I understand your explanation, but of course, you have a specific position within this court. So how do you perceive the principles of impartiality and objectivity in the professional activities of a judge and the role of a court president? It's a general question.
Я пояснюю далі.
So let me explain further. After the Council of Judges made the decision, the information was leaked to the judges, and they were confused with item 6 of that finding, that I had not communicated that finding to them because they believed that their guarantees were affected, the guarantees of independence and their rights. Thus, I decided, when I received that decision at the meeting of judges, I gave everyone a copy of the finding and asked them to convey that to the judges. And then, basically, it was up to them to act. The letter that you have read, well, I saw it when I received your case file materials. And I found there another letter from a group of judges. So that's what I did as the president of court. I also addressed the Council of Judges as the chair, because these issues are relevant for the entire judicial system. It's not an individual issue. I need to understand how judges need to act in those situations, including me as a judge. And we received the respective clarifications about that there was no conflict of interest in those situations where I acted as the judge, and the parties were the prosecution bodies and the state service party. And I believe that I did right. I could not keep them not in the know, because there would be doubts about our impartiality. We need to make sure that we are impartial. But then, if I could ask you for 1 minute of time to comment that in the judicial systems, in the judicial contexts where our international partners developed and our context, they are different. And here, for self-recusal, there is a disciplinary liability, and that's not an easy thing to do that. The only body that decides on that is the Council of Judges. And if there is no proper justification of self-recusal, there is liability. So that's our situation. And of course, your standards are different, and we are implementing them in our system, but maybe we are not yet there, not yet at the level where you would like us to be. So I believe it makes sense to consider our situation and judge my moral qualities in the context of our realities. Thank you.
Thank you for this explanation. Indeed, the issue of conflict of interest and judicial impartiality is actually the core issue for every judiciary, not just Ukrainian. And that's why the AGE also developed methodology how to assess situations which might be in conflict with this basic principle. And that's why we are very strict with respect to, in particular, the standard how the outside world could see certain situation. I believe that you, as a judge, are impartial. Problem is how the outside world sees certain situations. But I have another question, and this question relates to one court decision, which was then somehow scrutinized by the European Court of Human Rights. You probably remember the judgment of 9th March 2017 in the case of Kuzmenko versus Ukraine, where the European Court of Human Rights concluded that the Ukrainian court had violated the very essence of Mr. Kuzmenko's right of access to court and found a violation of Article 6, paragraph 1 of the Convention, given the refusal of the national courts to consider the applicant's claim and the subsequent referral to a procedure that was not accessible and did not ensure prompt and direct consideration of the claim. So you were the presiding judge in the consideration of Mr. Kuzmenko's cassation appeal and dismissed it, upholding the decisions of the lower courts, which had refused to commence proceedings under administrative procedure. And in the written explanation, it was said that the European Court of Human Rights has distorted the circumstances of the case. Can you explain in more detail what you exactly what exactly you meant with this distortion of the circumstances of the case?
Thank you for your question. I was speaking about distortion of the circumstances. So that was about the search that was conducted in the course of criminal proceedings, and that citizen appealed to administrative courts requesting that they deem these actions as illegal. The first instance court refused to initiate the case. The Court of Appeals upheld that, and when it was submitted to the High Administrative Court of Ukraine, it was presented to another judge, and I was a member of the collegium, and back then we had those procedures that I was also the presiding judge, because now it is the judge rapporteur who is presiding judge. But back then it was me, and we agreed with the judge that those actions of the operative staff of the task force in the criminal proceedings need to be tested by criminal courts in the course of criminal justice. Back then, in 2006, there was case law. Back then, there was already the decision of the Grand Chamber of the Supreme Court, where it was clearly stated that those actions that are conducted in the course of criminal proceedings need to be tested and monitored by criminal courts. There were two decisions of the Constitutional Court by then, where they also emphasized that when the relations were regulated by the criminal proceedings, the defense also takes place in that context. So we upheld the decision of first and second instance judges. We supported them, and we explained, we said like, please proceed further in the criminal proceedings. The citizen did not do that. He went to the European Court for Human Rights. And based on the content of the decision of the European Court, we can see that the citizen had exhausted all the opportunities to defend himself within the national judicial system. And since the Code of Criminal Proceedings was not clear enough, they did admit violation of the right to being protected by court for that citizen, even though more than 10 years passed since we had made that decision. I believe that the European Court should have explored, analyzed the case law that we already have in Ukraine, that there have been those decisions of the Supreme Court, of the Constitutional Court, that the criminal proceedings had to apply. That's my position and my vision, and since I am managing these issues after that decision of the European Court, the judicial system of Ukraine is at a loss, and there is quite a lot of confusion in this category of cases until now. Thank you.
Don't you think that, for example, as a candidate for the Constitutional Court, don't you think that it should be the other way around, and that the national courts in Ukraine should analyze the case law of the Strasbourg Court in relation to Article 6 of European Convention of Human Rights, to incorporate and apply the standards developed through the case law of the Strasbourg? So should Strasbourg Court follow the Ukrainian national case law, or should be the other way around?
Well, we have the Ukrainian law on application of judgments of the European Court for Human Rights, and there is Article 17, where it is clearly stated that decisions of the European Court are the source of law, and thus the decisions of the European Court are the source of law for us. They are important for us, and we apply them. And if that decision is available, I believe that it would be difficult to apply the case law, because, I mean, judges of the Administrative Court do not understand how they can check, inspect, and investigator and the process of a search that was conducted in the criminal proceedings. Maybe it requires clear explanation of the decision of the European Court, and our legislator needs to word that clearer. And I believe that was the intention of the decision. Of course, we need to follow decisions of the European Court, but when the citizens' cases are considered, I believe that the European Court does need to take into account whether at the national level all the instances have been kind of used. You were asking me about my opinion, and that's my opinion. And of course, the decisions of the European Court are source of law. We must implement that, and that has priority over national decisions, of course.
Question. Sorry. Excuse me. I have another question with respect to the possible conflict of interest in cases involving the former president of Ukraine, Mr. Petro. From 2015 to 2019, you were appointed by the previous president of Ukraine, Mr. Poroshenko, to the Constitutional Commission, which was an advisory body to the president. During the work of this commission, You were repeatedly a member of the panel of judges who considered cases in which the president of Ukraine, Mr. Poroshenko, was a defendant. So you did not recuse yourself from it. Can you explain why?
Е,
Yes, I did not recuse myself because I do not see any private interest on my side there. With President Poroshenko, I don't even know him personally. Speaking about my involvement in the Constitutional Commission, well, maybe I need to stop my judicial activity at a certain point because I'm always on some commissions. I'm dealing with various subjects of authority. I participate in various conferences. I mean, well, I did not see any grounds for self-recusal.
Your colleague did. The judge of the Cassation Civil Court of the Supreme Court, Petro, recused himself from the case where the defendant was President Poroshenko, and he did it on the grounds, and I quote, that the participation of him in the Constitutional Commission may at least raise doubts, including potential doubts of the parties to the case about the objectivity and impartiality of judges and the court in the consideration of the case. So why didn't you apply a similar approach as your colleague did?
е,
Every case is individual, is different, and every judge is also an individual. Maybe Mr. Uspenik had some different kind of relationship with President Poroshenko, but in that situation, in that case, Petro Poroshenko was acted as a private individual. He didn't act there as a president of Ukraine. That was about private relations. All the cases that I hear and where the president of Ukraine is involved, he always acts there as an authority, not as a private. No, there was one case, though. Now we are hearing a case, and I'm a member of the collegium where Mr. Poroshenko challenges the sanctions that are applied by President Zelensky. So now it's ongoing. But I was on one of the commissions, one of the boards that was set up by President Zelensky as well. So I announced it to them before the court session. I announced, I basically shared these decisions made by Uspenik, and Mr. Poroshenko was there in session, as well as representatives of Zelensky, and none of them requested my recusal. They trusted me to hear their case. Thank you.
Thank you. There's another potential case which raises some doubts. Namely, your sister has been a judge of the Volyn District Administrative Court since January 2012, and you have participated in at least 2 cases where this court was a defendant in the lawsuit filed by judges of the same court. You did not recuse yourself from these cases. Can you explain why?
Yes, I participated in hearing of 2 cases against the Volyn District Administrative Court, where my sister works as a judge. However, these cases, they had a particular nature. In one of those cases, the judge appealed to court because his years of experience was inadequately calculated. So he was the plaintiff, and the president of court was the defendant. And yes, my sister works there. Another case was about some compensations, payment of some judicial compensations, and also the judge appealed against the court. So I believe that if Volyn District Administrative Court were a defendant in the case where the plaintiff is a citizen, a third party, for example, the citizen complaining about non-provision of some publicly accessible information, there, of course, I would raise the issue, I would recuse myself, because that would give some concerns, raise some concerns of my impartiality, regarding my impartiality. But in that situation, I saw no particular reasons for recusal. Those judges know me, the president of the court knows me, and I know them as I know many other judges, and the fact that my sister works there has nothing to do with my need for recusal. And I also indicated in my written explanation that there was also the decision of the European Court for Human Rights there, that it is not a mandatory ground for self-recusal. And when a legal entity has an employee who is a relative, the first level relative, so for example, the father is a judge and the child works in the court, that's not a mandatory ground for recusal. So I didn't see any private interest, more so from the side of my sister. The plaintiff and the defendant were judges. I also contacted the Council of Judges about that, and they also stated that they saw no conflict of interest there. And those cases were ruled justly. One of the judges lost, another one won the case.
You contacted the Council of Judges afterwards, not before you was deciding in this case.
Так, пізніше.
Yes, it was later, because I did not hope that, I didn't expect that it would be an issue. But later I did contact them to learn some lesson for the future and for my colleagues as well, because I didn't personally go to the Council of Judges. I mean, not for my individual reasons. I'm worried, I'm concerned about the system. I want to make sure that other judges don't have those issues. And when they sit in my chair here, that they could be guided by some case law, some standards and approaches where we have this discussion and you indicate some drawbacks.
Thank you. I will now pass the floor to my colleague, Mr. Vasil Shakun, to continue with the review.
Hello, Mykhailo Ivanovich, hello. I have several questions that were prepared by the Secretariat and that require certain clarifications or explanations. That's about your academic activity. And one of the questions is the following. In April 2021, you co-authored an article, Cassation Filters in Administrative Proceedings, a step to the abyss or the novelty that Ukrainian society has been waiting for. In a part of these articles, that's the review of literature, of references. You used fragments of article published in 2020 by Savchak, Legal Nature of Cassation Proceedings in Administrative Proceedings of Ukraine. How can you comment on that? Okay, I thought that we would proceed with discussion of that decision. Okay, let me look for this file. Here it comes. Okay, so I have the following explanation regarding Savchak. When we take sources, references, see, look, Savchak, legal nature of cassation proceedings in administrative proceedings of Ukraine. I do mention that in the list of references. When I submitted this article to the respective journal, I did have this footnote. But I believe that what happened was that, well, anyway, this publication is included into the list of references. And why the footnote disappeared, I don't know. As far as I understand, this is now quite a challenging situation, because before publishing an article, there are quite a lot of peer reviewers who may edit the paper. So maybe somewhere in the process this footnote was lost, but definitely you can see this publication in the on the list of literature. Well, okay, that's clear. Then we've had this question already, this episode of your academic biography, and that's defending your thesis, doctoral thesis, at the International Academy of Personnel Management. You know, it was the period when many people tried to defend thesis. Back then, there were no legal grounds for this process, so you also did that, and maybe that was quite a trap, defending your thesis in that academy. My question is not so much about whether you defended that thesis or not. I understand that later you did defend a qualified thesis, a work that was quite a success, but when you realized that that could raise doubts of your academic integrity and so on and so forth, did you try to withdraw, to annul that diploma because it was received in an improper way? It's not about the paper as such, because the thesis seemed to be further on defended successfully, but back then there was no official qualification. Well, I understand what you mean, and there let me comment in this way. The theme of my thesis, PhD thesis, was approved by the Academic Council of Ostrogska Academy University back in March 2008, even though I started exploring this field of law much earlier. After I passed my postgraduate exams at the National University Ostrogska Academy, and the academy at that point did not have the academic council, so I needed to look for a university where they did have such a board. That is why, upon my request, upon my application, they transferred me to the Department of Law of the institute named after Vladimir the Great, and that's a structural unit of the Interregional Academy of Personnel Management. So there I worked on my candidate thesis, on my PhD thesis. In the process of that work, well, back then that theme was very relevant. because that's about jurisdiction of not only administrative courts, but all courts. And there my research advisor suggested that I present a report to the academic board. I agreed to do that. And then, according to the internal regulations, in the framework of the so-called informal education, I mean internally, locally, they indicated that as a defense of the thesis for Doctor of Philosophy within the Interregional Personnel Academy, and that's another unit of that. I agreed. They suggested that I prepare the report, and I have this report in front of me. And for that report, that lecture, I delivered it to the members of the special board, and as a result, they gave me that diploma of the Doctor of Philosophy of Law at the local level. So I did not attribute much importance to that, and I guess no one even knew about that. It's just you who discovers this fact 16 years after. I didn't use this diploma anywhere because it did not seem to offer me any benefits or whatever. And moreover, after 5 months, I did defend my thesis. So that's the story.
And now, when you're asking these questions, I started to explore it. I'm learning more and more about this topic, but the chair of the council had a stroke. He's receiving medical treatment. The management changed, and now I'm looking for local internal regulations which provided for these terms. This report is not published anywhere, so it's not a scientific source. The only thing I did, I prepared this report for myself and talking before special members of the special council and the audience. Also, let me admit that I have never thought about withdrawing this diploma, but I will consider it. Thank you. So you see, at the first look, it may seem quite innocent, but now the questions arise about the use of this report as a foundation for your PhD thesis. So, well, I think we will accept your explanation, but still I believe it's compromising your image. It's rather compromising your image than adding extra positive benefit. And I have another question. Tell me, please, at your workplace, have you ever used this diploma to get any extra payments? I'm sorry, no one has been aware of this diploma. I've just kept it in my cabinet. It does not make me eligible for any extra benefits. It's a local internal regulations. It can mean something only within the walls of academy, but I'm not sure that it brings some extra benefit even there. I have never applied for any benefits. Only after I defended my dissertation, my PhD thesis at the national level somewhere in mid-April. Then in May, I requested extra benefit from the head of the court. Okay, thank you. We have a few more questions. And one of these questions is about publication of your English article about administrative procedure in Ukraine, discourse analysis. The list of sources for this article consists of 92 sources. There are different sources, but at least 53 out of them are not related to either law or administrative proceedings and relate to various issues related to composite materials, building mixtures, computer systems, etc. I believe it can be an error of the journal that published your article, but you submitted this article to editorial office to journal. Could you please explain us the content of your article, explain the situation with the sources, and how did it happen that eventually the list of references and sources in your article contain a number of totally unrelated papers? Well, I have this English article. This article is in English language. I can share it with you. And also, all the sources cited in this article are listed in the reference section at the end. Moreover, I have over 150 articles, and I'm not just surprised, I'm just shocked by where these sources come from. My article was reviewed. I was told it was a blind peer review. So I can just share it with you if it's required, if it's needed. Here it is. But, well, the story itself, I submitted this article to the journal in early 2019. Then I sent 2 reminders to check on its status. I did not receive any response. And in late 2020, you know, I've already lost hope that it would be eventually published. But in early 2025, I learned that this article was in Scopus. Someone let me know about it. But after I reviewed it, I was also really surprised. I sent 2 requests with I submitted an original copy. I used since the very beginning, asked them to introduce relevant corrections and adjustments. My requests were ignored. So today I learned that according to the rules, it's impossible to introduce adjustments, and the only thing that can be done, and I'm requesting it, is to restrict access to this paper, basically remove this paper. This is the only way out of this situation. Okay, it's clear. And we have a few more questions that involve a third party. Therefore, we will kindly ask our technical team to temporarily suspend the broadcast. There was a report, so I don't think that it's a relevant source, because this source does not exist today. The only thing, I printed brief statements for myself to report before Academic Council at MAUP. But it was a kind of public approbation, public trial of before my future defense of my candidate PhD thesis.
Until 2009, you studied at the Interregional Academy of Personnel Management, which resulted in your defense of a dissertation and receipt of a document of this academy, a diploma of scientific degree, Doctor of Philosophy in Law. It is logical that such a diploma would not have been issued to a person who had not undergone certain procedures prior to the defense of the thesis and the defense itself. But at the same time, almost the same time, in March 2010, you defended another dissertation for the degree of candidate of law at the Academy of Management of the Ministry of Internal Affairs of Ukraine. How did you manage to conduct new dissertation research in such a short period of time?
Шановні
Dear members of the advisory group of experts, I never studied at Interregional Academy. The Interregional Academy has two forms of applying for a degree. One form is a postgraduate or doctorate training, and the second form, which was available back then, is a candidate as an applicant. I worked at Volodymyr Veliky Institute department at the Interregional Personnel Management Academy as a candidate. I did not receive postgraduate training there because I'm a judge. I'm supposed to work, and as a candidate, I engaged only in my research activities with my scientific advisor. And before defending my candidate thesis, the interdepartmental session is required. It was conducted at the Interregional Academy, and at the same time, since my academic advisor was a part of the academic council, he was not a part of the special council, but a part of academic council. So, based on the local regulations, I could defend PhD thesis in law at the International Personnel Academy in two forms, as a dissertation or as a report. So I talked to my academic supervisors, and we agreed to conduct this kind of approbation in form of report. So I defended for my PhD thesis in the form of report in line with their internal regulations. It's not a PhD since 2016. It's the local internal scientific degree, which, well, maybe has some significance, or maybe it doesn't matter at all. It's it's relevant in the Interregional Personnel Management Academy, but it was a kind of trial before my future candidate of law thesis. So there is no relation between the sources. Yes, I did not use this particular article to defend my candidate thesis. I don't object. I'm not trying to refute it. It was a trial, approbation trial. It was quite useful. You know, delimitation of jurisdictions, judicial jurisdictions, administrative courts. They were just interested to listen to my report. And based on the results of this report, I received a PhD diploma issued by International Personal Management Academy. I do have it, but according to their local regulations, I obtained it in a proper and correct way, fully in line with the statute. And it was allowed by the law of Ukraine on education. So, I don't see any problem here. Well, I don't think that I was supposed to refer to it in my future candidate of law thesis, because it was approbation. It was a trial of my research. Thank you.
The questions which concerns third persons. Would we please close the broadcasting for this purpose?
Прошу зупинити трансляцію.
Please suspend the broadcast.
Продовжуємо трансляцію.
We resume the broadcast.
Thank you. So I will now say just at the very end, very last question to you, Mr. Smokovych. The advisory group of experts received two quite urgent decisions and one letter from the Council of Judges regarding your application as regards conflict of interest. We receive two appeals from more than half of the judges of the Cassation Administrative. We receive numerous scientific conclusions from different institutions, everything related to your case about the conflict of interest. This is actually the first time that AGE experienced something like that. Don't you think that an objective observer may perceive this as showing your informal influence on the high state bodies, high state functionaries and others, to actually support your application for judge of the Constitutional Court of Ukraine?
Що стосується Ради суддів,
Regarding the Council of Judges, let me explain that I contacted them not as a candidate for Constitutional Court. I have to admit that your comments need to be conveyed to all the judges so that judges could all take that into account and to avoid further on any doubt of their impartiality. The Council of Judges, they consider aspects of conflict of interest. I believe it would be helpful if judges understood how they should behave in this kind of model situations. Regarding the research institutions, for us, for all the judicial system, I believe these aspects of conflict of interest, recusal, self-recusal for the National School of Judges, that will be helpful to develop training course maybe on those issues. Because judges must not make mistakes, and we need to make sure that nobody has any doubt of their impartiality. So, to some extent, this comments of yours help us implement this into these approaches into our legal system. And you told me that I have the right to refute, to challenge your doubt or comments. And if we speak about self-recusal, I was thinking about what kind of proof can I come up with, what kind of evidence. So, at least in the legal context that I'm functioning in within the regulation by the law, I understand that you don't take that into account, but that's important for us, for judges. And I submitted the memo on the sanctions for unjustified self-recusal. So I do all of that in order that our judges could develop, could go a level up. But frankly speaking, there are still quite a lot of threats, hazards, because we will see maybe more self-recusals and there is the risk of abuse. Me, on the contrary, I believe that self-recusal is a situation where the judge does that if they are concerned about their objectivity, impartiality. So, but I do believe that this decision needs to be substantiated. There needs to be some evidence of private conflict of interest. Even the proof that the third party may have doubt about that. I mean, your question whether the observer may have that thought, well, maybe, but I'm not doing that for myself personally. I cannot just stay aside. I am president of court, and in our system there is more than 1,000, actually 5,000 judges. And we need to convey that to them. We need to train them to make sure that if that's a mistake, that they avoid these mistakes, and so that in the future you or your successors did not have questions or comments about other judges. We want to live in this legal context as you are, but still our context is a bit different. That is why I ask you, when you evaluate my moral properties, I ask you to maybe step a little bit into our legal context, so that you are more on equal grounds with me, because I'm living here in Ukraine. So I believe that the observer should not really have any doubt about that. I have some private interest, whatever. I'm doing that for the sake of the country, for our judiciary, so that we could reach the adequate level as in advanced democracies in European and other countries.
Thank you, Mr. Smokovych, for sharing your opinions with us and answers to our question. I have no further question, and I pass the floor back to the chair of the advisory group of experts.
I have a question or two that I'd like to ask, follow up. The last question that was asked by Alice, I don't think was fully answered, at least not to my satisfaction. My question, and the question that was asked, did you ask or encourage or in any way be responsible for the barrage of letters that the AGE, the Advisory Group of Experts, received on your behalf?
You mean from the Council of Judges, right? From the Council of Judges, I did send you 2 letters, 2 decisions, because me, as the president of court, I contacted them as a competent authority for them to come up with explanations and recommendations on the conflict of interest. That's about self-recusal situations. If some relatives work in prosecution bodies, if the court can hear the case, if the prosecution is a party in a case. And the second important aspect for us now, that's if there is this collaboration between the research advisor and the postgraduate student. And then the postgraduate student takes some positions, if that's a conflict of interest, if the legal entity where the ex-postgraduate student is a party. So I would like to tell you that that was active discussion by the judges, because judges, many of them are lecturers, they have students. There are judges, for example, who were postgraduate students and they are their research advisors. Can they be on the same collegium and hear cases, for example? So is that a conflict of interest in that situation? So that's still an outstanding question. It requires deeper research. But as of now, the Council of Judges came up with their response, and they say that there it's important to take into account private interest. So regarding those two clarifications that I submitted to you, they were made by the Council of Judges upon my request as one of the factors. But in the preamble, you will see that there were much more sources of that, because judges have come to the judicial system who used to work as defense attorneys and prosecutors, and all of them are interested to know what to do around that, if there is a relative situation, or if a law firm can be a party, or if a colleague who used to be a co-worker and now they represent a party, if that's a conflict of interest. We have a lot of questions around that. So the Council of Judges has an ethical committee, and they make the respective decisions and give us these explanations, and that's binding for us. Thank you for your question.
It seems to me that so many of your responses are couched in terms of, well, you have to understand how things are done in the Ukrainian judiciary. And we are not, we, the international members, are not familiar with how things are done in the Ukrainian, system, and then we should be, take that into consideration. But conflict of interest is not a subjective standard, is not a subjective concept. It's objective. And what you're asking, what I understand that you're asking, is that it should be subjective, and it should be case by case, and we should look at each circumstance and then make allowances, and that doesn't help your judiciary establish standards that are universal, that people can understand and apply, which is really not a hard concept when you think about concept or conflict of interest. So your justifications, I know that you're offering justifications for the issues that we have identified, but I have to tell you, it doesn't help the judiciary in this country to continue to rely on a subjective conflict of interest analysis when you're looking at your problems, when you're looking at the questions that are put forth by the advisory group of experts. We are charged with the responsibility of vetting candidates for the highest court of this country. And quite frankly, a court that I understand has not always been as functional as it should be or as trustworthy as it should be. So our responsibility, I think, is one that's a very grave responsibility. And we can't be swayed by the request for subjectivity. So I just want you to understand that when we make our analysis.
Це питання мені?
Is that a question?
It's a observation, I think, and it's
Дякую за коментар. Дуже дякую.
Thank you for that observation, and definitely we are open to learning, and we are teachable. We implement all the standards in Ukraine. This is work in progress, and we understand that to define impartiality, we must use both objective and subjective criteria, but of course, there is still way to go. Thank you for your comment. We'll proceed. Yaroslav. As you have explained, one of legal reasons that you got hold of that four-bedroom apartment was that you have children older than 9 and of different genders, but the reporter corrected that the son was 8.5. But what about now? The daughter is 22, the son is 27, and they are living together with you, or maybe they already have their own families and they have moved out. So where are they? What are they doing? They are living with me. My daughter is studying. She is in the first year of her studies. That's a Department of Architecture at Kyiv National University for Construction and Architecture. My son has been drafted, and he is in the army now. In your apartment, your mother is no longer there, so you managed to place them in different rooms. Going back to the apartment was allocated for 5 individuals, and for 5 individuals we needed 4 rooms. Even if my mom were not there, we would need a 4-room apartment. And yes, now the situation is fine. Another question about the decision of the European Court, which stated that Ukraine violated the international commitments under Article 6, the right to fair trial and limited access to trial. However, I checked your biography, and soon it's going to be 30 years of your experience, right, as a judge. So maybe you have made several thousands of rulings. So have you ever tried to calculate in how many cases decisions of the courts where you were the rapporteur or where you participated otherwise, that further on participants of parties to the case would go to the European Court appealing against the state of Ukraine? And if so, in how many cases those complaints were accepted, and what was the decision of the European Court? In how many cases they rejected or were on the side of the plaintiff? Yeah, I know those figures. And that was one decision of 2017, as you mentioned, in Kuzminka case. And there is another 3 more decisions. I don't remember surnames of the plaintiffs, but 3 more decisions in so-called pilot cases. Pilot cases meaning about social payments. However, in those decisions of the European Court, in the pilot cases, it was indicated about a too long duration of consideration of the cases. But those cases they were revised by Cassation Court, and I was a member of the collegia, but the cassation instance courts did not violate this term. It was violation on the first or second instance, but the European Court deemed that the term, the deadline for consideration was violated without detailing that, and all the judges who participated in those proceedings automatically are affected. It is deemed that they violated Article 6 of the Convention. But for your particular rulings, no, nothing like that. Dear colleagues, any other questions to the candidate? Then, Mykhailo, you have the opportunity to make a closing statement. Dear members of the advisory group, thank you so much for this open exchange and discussion. I understand your approach to assessing the questions, issues regarding my activities. And I would like to ask you to stop participating in this competition. So I claim that I stop participating. Thank you. And that's your official statement, that you stop participating. Yes, it is. Thank you, Mykhailo, for your answers. Dear colleagues, here the interview of the advisory group of experts with Mr. Smokovych is over. Dear colleagues, the advisory group of experts has held interviews with all candidates for the position, and I understand that as of now, 4 candidates continue participating in the competition. Soon, the advisory group of experts will make decision on compliance of the candidates with the criterion of high moral quality, so follow the news of the advisory group of experts. And here we conclude.